Still Ways and Means Committee, still S-198. I want to going to bring people's attention to some testimony on our website, but now I'm not seeing it, actually.
It's under public comment.
Nope, that's not the one I was looking for.
No.
Nope.
No way.
It's from a tobacco wholesaler association, but I don't see it on our website. Thank you. It's going to get forwarded to Source and posted. And Department of Liquor and Lottery is going to testify again. If you can. Thanks.
Okay, thank you.
Hi, everybody. My name is Hannah Chauvin. I am here for Liquor and Lottery. I want to forward this letter before it gets away from me.
And while you're inside your computer, just want to clarify that while this bill has had a lot of time in commerce, healthcare, and human services, the issue of the tax stamp was one that was reserved for us because we're the tax committee. So none of those three committees have had a conversation about this very particular narrow issue. They've talked muchly about the dangers of tobacco and tobacco substitute products and all kinds of other things. They've talked about the regulatory, they've talked about the retail, all the things. They have not talked about the tax stamps. That is strictly our jurisdiction. Though if we amend the bill, all those other committees would indeed vote on the amendment as any other time, but it would not get referred back to those committees. It's just to go through its usual process.
So they would do their little thing on the floor where they kind of huddle and say yay or nay, and then they announce it on the floor.
Yeah, or if someone or whoever's reporting the bill would go to that committee and tell them about the amendment. We do that sometimes too.
I'm not sure if this is supposed to be shared because it was told to me in a squirrel committee, but we heard that everybody else voted no. And we'd be the only ones voting yes. That's not true at all? Okay.
All the other, this bill passed all those other committees, and this issue is reserved for us, is my understanding of the situation.
And did it pass every other committee?
Yes, the bill passed all the other
Without-
committees, without this thing in it, but this thing is just our thing. So the debate about getting in front of it versus not getting in front of it is certainly most played out. Would you like to speak?
And I did email the letter while I'm posting
Thank you.
it. Everybody.
So I just want to reiterate Commissioner Knight's points that this has been, and Todd's points, that this has been an immensely collaborative process between Liquor and Lottery and tax and the AGO and advocates. And I think we are all keen for it to move forward. The Department of Liquor and Lottery is not shockingly, nor do we endeavor to be the tax authority. So I don't.
Only the tax authority.
But I do want to just emphasize the value that we see in studying this before putting into any mandate. So we would be, as has already been said today, the first state in the nation to introduce a tax stamp on on tobacco substitutes, essentially. This committee has not heard, but has just received a letter from the Wholesalers Association with some information about how industry sees this. Testify, but I do just want to reiterate the department's support for studying this. There is a lot to be learned. I think when you are on the vanguard of any policy change, particularly industry-wide and countrywide, I think it would be good to study it and to see what that would look like in application. Again, Liquor and Lottery isn't the tax authority on this, but when we go into a retail, a brick and mortar tobacco licensee, our investigators are looking at the products that they have on the shelves and what they have for invoices. So you've heard previously Commissioner Knight testify on the ways that S-198 strengthens the regulatory environment. One of those ways is by moving the licensure of wholesalers from tax where it lives currently to DLL effective next year. What that gives us is a clearer supply chain, clearer auditability essentially of a supply chain, so that when we have investigators go into a brick and mortar, they aren't just relying frankly on their knowledge of the wholesalers that we, through regular interactions with this work, know to be licensed. We have that licensure information that becomes public, whereas where it lives currently is tax, it becomes privileged tax information. So there is some nuance around, even with current tax stamps on tobacco products and potentially future ones on tobacco substitute products, who is the investigative and enforcement authority on that. That would be a key part of any study and of any further legislative consideration.
You speak to a brick and mortar inventory audit, if your compliance officers go in, they're doing an inventory of what's on the shelf, or they're doing an inventory of what's in the back room?
Yes, to both of those. So, and I'm happy to have our enforcement team write you up or walk you through exactly what that looks like, a field trip perhaps. But we have an investigator go in and look at, they ask for for the invoice of the retailer, what they've purchased for tobacco products. As I've said, and sorry to sound like a broken record, because tax licenses the wholesalers, that becomes privileged tax information. So the Department of Liquor and Lotteries, OCE, Office of Compliance and Enforcement team doesn't have a list of every wholesaler that has been licensed. What they are looking for with that invoice is, does it come from a wholesaler that we know from interacting with this board regularly is a licensed tax entity? And what's on the invoice match what's on shelves and what's in the back of the room? Were we to find, for example, a significant amount of product that wasn't on invoice, that would be obviously a flag for us. And if we were to identify an invoice that came from a wholesaler that we weren't familiar with, we would refer them to the tax department currently. That would change when this goes into effect next year.
So the compliance officer going in has no idea what number they're trying to hit. Right? They're not trying to see, I need to see that there's 50 cartons of the substitute product. They're just going in and doing it and then comparing it to a paper invoice.
Yes,
Very paper driven.
it is. I'm not sure what you mean. Can you clarify number that they're trying to hit? They're trying to match physical inventory to
Yeah.
invoice.
Whenever you do an inventory, either you start with the number you're trying to reach, or you just do the inventory and see if that number matches the invoice.
I
You have a starting point as the investigator going
happy to get back to you on how they approach that operation.
in, about a retail process. Yeah, it's just the difficulty of recognizing what you're saying is that they don't necessarily know, the compliance officer, what is coming from a licensed wholesaler without a stamp.
Well, what I heard is that something that will, and please correct me if I'm wrong, but what is going to happen in this bill as it came to us, regardless of an amendment, is that DLL will now have a list of
Right,
the licensed
wholesalers, right.
wholesalers, which they do
They
not
don't,
have right now.
Yeah, got it.
And so that will still be a big step forward towards compliance, even without the stamps being required. Thank you. Oh, sorry, Representative Finnegan.
Two things, this is not a tax increase, is that correct? It's just, the stamp is reflecting the fact tax has already been paid on this little carton, is that
I
correct?
think that's a great question
Yeah.
for Abby or Ted, but not Department of
Okay.
Labor.
All right, then, thank you.
Thank you. Abby, do you mind joining us again? Because I think you raised some concerns with me, and then I also had a question about weight and how that would work for a stamp.
So, for the record, Abby Shepherd, Department of Taxes. Could you repeat your question? Are you speaking to the amended language or the proposal from the Attorney General's office?
I don't know, I'm speaking about the stamp itself, by putting the stamp on the package. Is that reflecting a tax increase, an additional tax? Or does that simply mean that the tax on the box has already been paid and?
Oh, yes,
because-
under current statute, yes. So it's showing that tax has been paid, it's been stamped. And it's the wholesaler typically that's doing that.
Okay.
So I'm saying typically because technically under statute, we have the authority to, if a retailer has any product on their premises that has not been stamped, then we can require the retailer to pay the tax, but that's typically it's the wholesaler that's paying.
So what's the big deal about this?
I don't know if I can really speak to that. We're not necessarily advocating for this change. What we're really supportive of in this bill is shifting the wholesale enforcement licensing to DLL. We do think there's a good case to be made for setting stamps and figuring out a way to do it that we could administer. That's really our biggest concern, is making sure we can actually show that the right amount of tax has been paid. So that's something why we think we need a little more time rather than moving forward immediately with, and the bill that came over from Human Services does not have an immediate new statute imposing a stamp. It's the proposal from the Attorney General's office that would change statute, but it wouldn't be until 2029. So there would still be time to make any changes.
Do you, as the tax department, have worries that these folks are not compliant with state law in paying their tax?
Under current statute, we are confident that we are, having good compliance with our tax statutes. And we work with the Department of Labor to administer the taxes.
Thank you.
But again, there are new products always coming on the market, and we try to respond to, concerns there.
Is there something, some of the products are taxed by weight? And is there concerns with how that tax stamping would work? Is that one of the reasons you need to study it more?
So for I don't think that the way that the current stamp taxes work, they apply to cigarettes and they apply to certain cartons. The new products that will be subject to stamp tax, I think those are all outstanding questions. I don't think that we have an answer today. And again, that's why we think the study is really important to ensure that we can actually stamp these, that, will this be a manual process? Is this something that machines can actually handle? I think these are all outstanding questions. Like the stamps that exist now would not work for tobacco substitutes, vapes, any of these products.
Do you all feel like that's like will all be easily resolved through the course of the study?
I don't know.
Okay, that's why we're studying.
Yeah, exactly.
Yeah.
That we could work with the industry. You could hear from them about the ways that they can adapt to this, because right now there are machines that do the vast majority of these.
And so some of the complications that you're foreseeing right now, though, of course, one of the reasons you study things is for the complications you don't foresee, are like weird shaped things
And different weights.
and different weights and different
Concentrations.
concentrations. And those are all at different tax treatments. They need different stamps. Maybe.
Again, I think that
Oh, yeah.
other states have been looking into this. We would look to what other states have considered, if there are other options. We have not proactively done any studies on this yet. I don't like have a recommendation to solving this problem today. There is one other thing I'm not sure I made clear in my testimony earlier. I just wanted, if you are moving forward with immediately enacting a new stamp tax in 29, I would recommend strongly that you clarify that you would not be double taxing those products, that the definitions right now would also be amended, so you wouldn't have a new smokeless tobacco products tax and this new stamp tax. It's just my one little drafting concern.
It's a good one.
It's not a little one.
It's kind of a huge one. Thank you. Other questions for Abby? Okay, thank you.
Thank you. I can stay this time.
Appreciate it. We now have transportation and tobacco all in the committee room together. What a pleasure of mixing things. Do you have any? Or should we be waiting? Okay, great. So, thanks. Yes.
So I'm a little confused about where we think this makes sense to go right now.
I personally feel like it probably makes more sense to study it and then implement it.
Then in that case, does it make sense? to
It does not, but just a few minutes ago, everyone seemed to be feeling very warmly towards the idea. So I don't want to get, and I wanted to open it up to the committee, but
I was feeling very ambivalent and therefore was quiet. I am feeling more and more like we need to study it first.
Okay.
Then do something appropriate based on that.
okay. 1 second, Mark. You are too, Representative Brennan?
Yes.
Okay,
Study.
okay.
And in part because I don't want to mess up the good work that's already been done on the bill. It seems like there's an enormous amount of work that's gone into this to get it this far, and I don't want to step on that.
Yeah, great. Hi.
Fine, sorry I'm late.
It's okay. All kinds of things have happened while you were gone.
About the stamping and.
You are indeed talking about the stamping.
Green.
Okay, great. Representative Odie.
After the break and understanding some things, I also want to say, good, wait, did not know this was.
You know,
To do.
everything is a big to-do, and sometimes we only just get to spend a few minutes on the to-do. So we don't find out about all of it. So do folks feel comfortable voting the bill out as we received it?
With the study.
With the study,
But no stamp.
but no stamp? Okay. Does anyone need anything else before we do that?
And no tax increase, right? Same old, same old.
The revenue is basically the same, right, Ted?
Yep, Democratic current fiscal office, there's some fee increases in the bill, but there are no tax changes.
These are not taxes.
That is true, ma'am. You haven't said that in a while. It makes me great. Okay, someone make a motion then?
Madam Chair, I would move that we find,
S-198.
yes, S-198, but version S-198.
It's as we received it, okay.
As received from Human Services,
Okay.
favorable.
Thank you. Any discussion? Seeing no discussion. Representative Burkhardt, can you please call the roll? Sure.
Representative Brannigan.
Yes.
I'll vote yes as Representative Burkhardt. Representative Higley.
Yes.
Representative Holcomb.
Yes.
Representative Kimball.
Yep.
Representative Maslin.
Yep.
Representative Odie. Representative Page.
Yes.
Representative Wozniak is not present. Representative Canfield.
Yes.
And Representative Kornheiser.
Yes.
We have voted the bill favorable 10-0-1.
Thank you. Thank you, everyone in the committee room and on the sidelines for all that work. We're gonna now talk about transportation.
Thank you.
Thank you.
Here.
We'll have a moment to change for changing the guard, and then we will pick up as 226, 326. Oh, there you are. Hey, I thought I'd seen you and then,
Oh, this is bad.
no, this is not, we have not seen this.
I just saw non-driver ID cards and stuff.
Oh, do you want it? You can see now. Okay, well,
Oh, am I done over there? I thought you said you. Yeah, that,
yeah, but it's in the session.
gotta. Yeah.
Good afternoon.
Good afternoon.
How is everyone today?
Been a wild ride. How about you?
It's another day in May.
Sure
It's
is.
fun.
How many days in May will we be here for, Damien?
Don't ask me that.
I will not.
I might break down.
Okay. S-326, let's talk about it. Let's not break down like the
I
car.
was faking happy so well.
They did. Senate Finance is deep in now. Yes.
All right, I'm joining your Zoom meeting. Now I can share my screen. Fortunately, this is a fairly straightforward amendment draft, and then I'll work it off to the other folks. The draft, I'll let you talk about the issue. The other thing that's worth mentioning is that the drafter of this amendment was Kirby. I worked on it with him, but he's the primary drafter, so you can trust the tax language. So
We
the,
need to go through the actual bill.
okay, do you want to do that first?
That makes more sense to me.
Okay, yeah, I guess it does make more sense.
You right?
Oh, boy, it's been a day.
Yeah. I had a moment where I wondered if we had blocked through the bill and I just completely forgot.
You are not wrong. Where's the? Okay. So what I'm gonna do actually is just pull the bill off the other committee's webpage rather than searching for it. Then I will pull it up and I will go quickly so that. All right. Great. All right. S-326 a 33-page bill. So the bill has, I'm gonna skip ahead to the tax and fee related provisions. The first is section 2.
Can we have like one sentence on each section?
Sure. Section 1 provides that, what section 1 does is it relates to non-driver identification cards under the federal Real ID statute. In order to avoid identification fraud, you can have either an operator's license or a non-driver ID, but not both at the same time. And so this brings our non-driver ID statute into alignment with the federal Real ID law. So basically, if you are getting a non-driver ID, you have to give up your operator's license and vice versa. Section 2 relates to insufficient funds for fees. So currently, the department has statutory authority if you bounce a check to first they send written notice, and then if you don't pay the amount that's due, then the commissioner can suspend your license or registration and until you pay the amount due in full. So let's say I go in to renew the registration for my car. So 2-year registration, $163. Maybe I have the infrastructure fee, which is another $178. I forget that I also put in my rent check. And when the check goes to the bank, it bounces. If I can't pay that amount due, and currently they give folks about 30 days to pay, so they get in touch and they say, pay up within 30 days. If I don't do that, then they can suspend my registration at that point. However, if I went in and did that with my debit card and I had the same problem where my check hadn't cleared to the point where the debit card would get rejected, but then by the time the funds request actually makes it through the bank process, which could be 3 or 4 days later, the funds are no longer in my account. The department doesn't have the legal right to suspend the registration in that case. So they're asking to make it the same whether you're paying by check or electronically. And then if you pay in cash, you're fine. But yeah, so for check or credit card or a debit charge, they're basically saying that if the money doesn't actually make it to DMV, then they can suspend your license and registration. And DMV can speak more to this. They do it, like I said, they have a process of 30 days where they try to make get the person to pay by another means or when the money's in the account or whatever. And then after those 30 days, at that point, they take action.
Representative Muslim.
Yeah, I don't know if it's a question for you or not, but in previous years, when we've taken testimony on fines for victim relief or funds and stuff like that. And if this is not quite relevant, I'm sure you'll tell me, but there's a question about trying to collect fines, for example, to go into the victim release funds. And then it's difficult to find those monies and pull them up. And so I assume that the long and short of this process is that problems with some funds not being available are probably pervasive of people who can't pay them. And it's not a statutory thing, but it's a question on whether the funds are available and how we get from here to there.
It's a question of whether the funds are available. It's also, but I think for this is really a question of, so we have in our law that if you want to register your motor vehicle or renew your driver's license, you have to pay a fee.
Sure.
And currently our statute only gives the department recourse to suspend that state issued privilege if you paid by check.
And you've answered the question correctly. And my question was a little roundabout, but now I understand what I need to know. Thank you.
Yeah. So it's a little bit different than a fine being issued against a person who's indigent.
Thank you very much.
Yeah. Okay, section 3, this is, you may have read about this in the press. This is increasing the fine for what we call a stuckage in Smuggler's Notch. So it's $10,000 if you violate the oversize or the size limitations and drive up into the notch past the point where you're not supposed to go. It's $20,000 if you get stuck. And then if you do it a second time in 3 years, which you'd hope after the first time you wouldn't do it again, but if you do it a second time in 3 years, the fine is doubled. So the transportation committees and the judiciary took testimony on this and looked at the cost to remove a vehicle, which can be excessive. In some cases, they need to literally cut the trailer in order to extract it in pieces. So it can be a recovery that costs thousands of dollars. The efforts they've taken so far with signage and chicanes and other public notification have reduced these from 6 or 7 a year to about 1.
And as fun as this all is and how much media loves it, we are not, fines are not in our jurisdiction.
All right. Updated signage is the next section. Section 5 is salvage titles, documentation. It allows electronically signed documents for when an insurance company takes title to a car that has been totaled after they've paid the damages on it. Or paid out the policy. Section 6 and 7 relate to 6, 7, and 8 relate to duplicate titles. So if you've lost or had your title to your car, your vessel, your snowmobile, or your ATV, this provides in statute now, because previously the statute provided that even if you went into a DMV location, they had to mail you the title. This allows them in statute to actually hand you the title if you're at the DMV location. Yes, this is the, this is why I love this role.
Doesn't deal with type cars that are beyond the requirement to be titled though, right?
Yeah, no, this is if you need to get a copy of your title and it's been damaged or lost. So, yeah. Okay. Section 9 is just clarifying where appeals go. This was requested by DMV's counsel, making clear that we don't appeal to the criminal division. Section 10 is clarifying some language around vehicles that don't need a certificate of title. It's just a technical change. Section 11, fees for towing from public property. This provides, and this is not a fee the state charges. This is an amount that the towing service can charge the state for reimbursement.
Oh,
So it's 200, it's increasing the amount the state reimburses from 125 to 250.
does the state then charge someone else?
There is a fund that sits at DMV that pays these amounts.
Great.
So, and this actually allows the Agency of Transportation to seek those funds from DMV, which is a fun bookkeeping if you think about it. Section 12 is a technical amendment to the diesel fuel tax. So it is renumbering these sections and subsections in here. It's not actually changing the language, but conceptually, the subsections and subdivisions didn't relate to each other, so it's breaking them out so that they're grouped conceptually. But it doesn't actually change any language except to add a missing by. By a machine owned by or under the control of a person. So Section 13 increases the fine for operation of an unregistered snowmobile or a snowmobile that doesn't have its decal for its trail maintenance assessment. Under the previous system, the fine was low enough that you were kind of breaking even whether you chose to register or risk the fine. And so it's increasing the fine to make it an actual deterrent. Section 14 provides an exemption from the commercial driver's license during emergencies for public employees who don't have a CDL to operate heavy vehicles as part of their official duties. Section 15 has a fee. 1 year, $40 fee for a non-domiciled commercial driver's license. What a non-domiciled commercial driver's license is there are two types of drivers who can get these. One are folks who are foreign nationals who are working in the US temporarily. So this basically allows them to get a license on a year-to-year basis. The other is if your authority has been revoked by the federal government to issue CDLs, residents of your state have to go to another state and get a non-domiciled license. So again, in that instance, let's say New Hampshire had their authority revoked. New Hampshire drivers could come to Vermont and get a non-domiciled CDL for $40 a year until New Hampshire got its authority back.
Is this like a thing?
It is. It's actually in the transportation world, non-domiciled CDLs are a very contentious issue right now. And
How often do states get their
authority revoked? Not very often, but there are currently some states where the federal government is threatening to do that because of the non-domiciled issue.
Okay.
So,
Damien, do they have documentation that says they've been trained and approved?
yes, this doesn't change their requirements to be trained and go through a CDL driving school, et cetera. So they still have to meet all the same requirements as any other CDL driver. This is just saying that for the non-domiciled drivers, instead of issuing a 4-year or a 2-year license, which may actually exceed the period that they can work in the US, and then that would violate federal law, we're going to issue 1-year licenses. So it's shortening it up to prevent instances where someone applies for a 4-year license and it mistakenly gets issued, even though they only have authorization to work in the US for another 18 months. So.
Other issues, Damien, we heard a lot about CDL drivers having to read English.
So that at the federal level right now, they are updating regulations about English language tests and also proposing to restrict which foreign nationals can apply for a CDL. So that is probably a preview of coming attractions for things we'll be working on in future years. But yeah, that's been an issue that's been in the news. There were some accidents in other states where one of the alleged causes was the driver not being able to read English and ignoring a sign and then causing an accident because of that. So, yeah. All right. Section 16 updates the hands-free driving requirements for CDLs to reflect that you can now text hands-free and have it read the text back to you. And so it allows hands-free use of a device and clarifies language around that. So the fact that you had a text message sent is not by itself going to be a violation if you had the phone in hands-free mode. So you cannot be holding the device, you cannot be touching the device, it has to be secured. There's all sorts of other things. But it's clarification about that, and it lines it up with our regular requirements for non-CDL drivers. Section 17 are motorboat validation stickers. This is a Coast Guard requirement. They have to be next to your registration number. And so this requires them to be within 6 inches front or back of the registration number. This is the kind of stuff you guys really like late in the afternoon on a warm day.
It's really working for me today.
Section 18 is a requirement for personal flotation devices during the colder months of the year, November 1 to May 1. Unless you are bow hunting or, I'm sorry, hunting or bow fishing in less than 3 feet of water.
In the warmer months.
No, in the cold months.
I know, but in the warm months, are you not required to have it?
You are not required to wear a life jacket in the warmer months. You're required by the Coast Guard to have one on board, but you don't have to wear it. So you may have seen folks with their PFD strapped to their stand-up paddleboard.
Isn't a stand-up paddleboard a PFD? In and of itself?
Only if
It's a
you're,
really contentious issue, actually, in my area for some reason.
yeah, so a US Coast Guard approved PFD will keep your head above water.
Paddleboard will not.
I mean, if your foot is attached to it, you could
Oh.
angling upside down. So it is something you can cling to. But the regulations, Coast Guard regulations require a US Coast Guard approved personal flotation device. I am not
Why
a
is
water
the US
safety requirements expert, so I just want
Why
to.
do we follow US Coast Guard law on our inland lakes and waters?
So because we also have lakes that are subject to federal jurisdiction and waters, Champlain.
But not the other one?
Um,
And then for me, that
I'm
goes-
from Magog, Connecticut River.
Okay.
Yeah, so there's a number.
But even if it's not subject to Coast Guard, we still apply the Coast Guard rules.
We have, in this case, we're saying US Coast Guard approved
Okay.
personal flotation devices. You don't necessarily have to follow all Coast Guard regulations on waters that aren't subject to Coast Guard regulation. In this case, we've said US Coast Guard approved personal flotation device. It's important to note that if you're on a US Coast Guard inspected vessel, which is a ferry across Lake Champlain or a commercial boat. So if you're on the Spirit of Ethan Allen, you don't have to wear a life PFD during cold weather months. They are subject to different federal regulations and work preempted.
And is this true in private bodies of water as well as public bodies of water?
This is true in all bodies of water in Vermont between November 1st and May 1st. It's not your swimming pool, but yeah. This would say that if you're aboard a vessel that's located in water that's not more than,
And then
that's more than 3 feet deep.
who's responsible for the violations?
Well, so that's the fun part of this. There is no penalty for a violation. So it's specifically exempted from the fine for a violation, and it's not subject to judicial bureau jurisdiction. So it's just it's a warning. It's not actually a finable offense. So if you're in a private body of water on your own land, I doubt that law enforcement is going to let you know. If you're out on Lake Champlain, they'll advise you that it's against the law, but they can't actually fine you.
I can't find you for not having a personal flotation device.
Not under this.
Even the Department of Fish and Wildlife. Yeah.
Under this construction, there is no fine, no penalty set for this.
We can move on now. I
Okay.
really just got an email on this last year, so I appreciate everyone their grace.
Yeah, there is required outreach and education on this.
Fantastic.
So next fall, look for it and then you can share it with your constituents.
Indeed. Thank you.
So K vehicles, these are mini trucks. If you all remember the mini truck day in front of the State House.
Busy in committee that day.
So K is short for Keiji Dosha, which is the Japanese word for light duty vehicle. So these are Japanese made vehicles that have to be below a certain size and certain engine output. And this clarifies that they can be registered as either a pleasure car, which is a standard motor vehicle, or a farm truck in this state. And then they're subject to the same requirements as those vehicles.
Are they registered now?
So currently, the DMV is registering them, but this came out of some confusion between different DMV locations. And so this is clarifying language just to clarify in statute so that folks are comfortable and there's clear language about them. One of the things with these vehicles is they are subject to federal import requirements. So because the majority of the older K vehicles did not get certified for the US safety standards, you have to wait till they're 25 years old to import them. And then you can import them to the US and register them. So because of the confusion around the lack of US certifications on the older vehicles, I think there were questions about inspectability, et cetera. And as long as these meet the basic safety requirements, you can register them and use them on the roads. They have to have working brakes and seat belts, et cetera. Section 22, this is the most popular section in the bill. This is an amendment to the inspection manual to provide additional clarity, eliminate outdated procedures, and provide more clear, consistent guidance for inspection mechanics and members of the public, and to focus on conditions of the vehicle that constitute an immediate safety risk in the vehicle. So DMV has been working on revisions to its rules, and this is saying, please adopt those rules. It authorizes them to adopt interim emergency rules this coming summer while they put the permanent rules through the rulemaking process to speed up the updates to the inspection process. Sections 23 creates a new definition for what is being called a limited use specialty vehicle. This essentially covers 2 or 3 types of vehicles, depending on how you draw the lines. One are what are known as kit cars. These are cars where some or all of the materials for the car come in a kit. You build it at home. You can then get it registered and inspected by the state and use it on the road. The next are these sort of very specialized vehicles. There's a manufacturer in Milton that makes these. They look like classic cars, but they are entirely modern. The one in Milton has a modern engine, a carbon fiber body, advanced electronics, et cetera. And then the third type are what are called, yes, very expensive. The third type are what are commonly called resto mods or restoration and modification, where you take an older body like a classic Porsche, you clean it up and you put fully modern equipment and bespoke this and that inside it. Also very expensive. These are basically the state is clarifying that you can register these for limited use. So 1 day a week, similar to an antique car, not for regular transportation of passengers and property. You can take them out in parades. You can drive them to your track day, things like that. The annual registration fee is set to match antique vehicles that are subject to the same requirements at $26 a year. So there were a lot of comments about the relative registration fee versus cost of the vehicles. I'll leave that to all of you, but it was modeled on the antique vehicles. And then the inspection system here, they're subject to safety inspection and visual emissions inspection, but they don't have to undergo the OBD systems inspection, which is where you plug in the onboard system, because some of these vehicles do not have an onboard system. The ones with a newer engine will. They do all have to meet basic EPA and California emissions inspection requirements for the year their engine was manufactured, though, when they're made. So the next section is license plates. It's clarifying that you cannot color, tint, or change the appearance of your license plate or cover or obscure the letters and numbers on it with any material. So this applies to those clear plastic covers that reflect sunlight or light of any sort to obscure the materials. And also what I understand is becoming a common process of folks taking their car to a place where they will custom color your license plate. So it's no longer green and white, but you can have green with pink letters, or you can get custom designs. Apparently, I did not know about this until this came in, but that's what this is with.
My understanding, there's also like screens to prevent e-readers.
Right, so, well, no, so this is license plates, but yeah, so this part here covers the clear plastic cover or other material you can put over it. So that like when you go through the Toll Plaza in New Hampshire and it does the flash to take a picture of your license plate, the license plate is blanked out because it's
So those are not
reflected the
allowed.
light. Those are not allowed either. So that covers everything here. It does have language added in to clarify that except as otherwise provided by law, so you can keep your Vermont strong plate covering your license plate on the front of your vehicle. And then section 28 provides additional requirements for motorcycle exhaust. Basically, you can't have a motorcycle with an exhaust system where the baffles, which reduce the noise, or the muffler have either been removed or bypassed, or there's a cutout so that they are no longer effective, or a straight pipe system that doesn't have any of these things in it. And it's a noise related issue. So vehicles that have that would fail inspection. This largely tracks what we currently do in inspection, with the addition of the straight pipes being new.
Straight pipes?
Straight pipes.
Straight pipes.
I'm sorry, it's been a long day. I'm starting to slur my speech. I don't know what that says.
So.
And then there's rulemaking. So you're here essentially.
I've heard sort of lots of State House gossip about that last section. So I just want to.
Yeah.
Does it change the enforcement of it at all?
Enforcement is through inspections. Theoretically, just like now, a police officer could pull you over for equipment, like if you get pulled over for having a light out, or there was a case that went up to the Supreme Court a few years ago for a noisy exhaust that then resulted in other things being detected. Yeah, so you could still be pulled over if an officer chooses to do so. But most likely this will be a point of inspection, and it doesn't make a substantive change to the current inspection manual, except for the straight pipes. So.
Which are purposefully loud.
They're purposefully loud. Essentially, a straight pipe is a pipe that has no muffling equipment in it. It is literally just a straight pipe.
Are there other loud additions that are already?
So this will not prohibit an aftermarket exhaust. So for example, one of the members in the House committee brought up that for some motorcycles, he mentioned Honda, their exhausts tend to be quieter when they come from the dealership, and folks will add an aftermarket exhaust that makes it sound lower or deeper. Those aren't banned as long as they have a muffler of some sort in them, a baffle, something like that, which prevents the full engine noise from coming out, but still. So there, you have to have some sound limiting device on there. There's no specific requirement for how much it has to limit it, and you can't disable it.
Yeah, decibel level.
No, there was the proposal from the Senate required that it be an EPA labeled exhaust.
They took that out.
They took that out because a lot of the aftermarket exhausts don't get EPA labeled. So.
Damien, is there the similar provision for just cars and trucks?
In the inspection manual, there is a provision that requires you to have a working muffler and requires a failure if you have any cutouts or bypasses to that muffler. There is not a similar provision in statute.
What about for hot rods?
Straight pipes, I think, would fail the inspection. So I can pull up the inspection manual and make sure that that's the case, unless the deputy commissioner knows off the top of his head. Yeah, so my understanding is that if you have a hot rod with straight pipes, you're not going to pass inspection.
Currently.
Currently. So you need to have a muffler on there, but I can confirm that.
I feel like that was just confirmed, right?
Yeah.
Okay. Anyone else questions for David? Oh, sorry.
So no, just to follow up, and I don't see it in here, but initially they were talking about decibel levels, and that's been taken out, I guess.
Yeah, so the EPA requirements essentially work out to, there is an EPA test where the motorcycle is driven at full throttle accelerating, past a point, so it's on a closed track with a professional driver, at a specific distance, it cannot exceed 80 decibels. As you can imagine, that's essentially impossible for an inspection station to replicate. EPA does stamp exhausts in vehicles that have met that standard, but aftermarket exhaust manufacturers often don't have a facility that can meet that standard, so they don't get the stamp. So other states have adopted other tests, but all of them they vary from, setting up a sound meter at a certain distance, like 2 feet away, to mobile sound stations and other things like that. All of them would require new equipment, new training, and they come with their own enforcement challenges. So Representative Keiser proposed this language here, which largely tracks the inspection manual requirements.
Thank you. It's great. Any other questions? Oh, yeah, keep on going.
Could we go back, and I know you said something, I didn't quite hear what you were saying, and that the smuggler's notch issue?
I was saying that we don't have jurisdiction over fines.
Yeah.
Could I still ask a question
Of
about
course
it?
you-
So who currently pays those fines for extraction? Isn't it, or I should say, who gets the money going? For the extraction, they pay a company that comes and record company, correct?
Yeah, so my understanding is that the extraction is a significant expense for the local first responders, and that they may try to seek compensation for the cost of the record. They may or may not be able to get all of that covered. But yeah, there's a significant expense from the wrecker, from closing down the road, and from other issues that may stem from that, because they have to close down 108 in both directions going through the notch, because for anyone who's driven through it, it gets very hard to turn around once you're in it. And so they have to close down the road for a number of hours. They have to get the wrecker out there. They may have trouble getting the wrecker compensated. The fines themselves, are also extremely high. So,
But there isn't like bill back authority?
so this is separate from the ability for the first responders and the wrecker to try to bill the owner for the costs.
Is there statute about that?
The statute that I'm familiar with does not specifically address that. I could touch base with our municipal team,
It's not really our business, but
but yeah.
Just one final question, I guess. With the current fines, have they looked at whether or not they've been able to receive those funds? I mean, if they have current fines of half the amount of money and nobody's paying, what good's it gonna do to raise them?
So I don't know I don't know the history of collection on the current fines. Do you have any more information on that, Deputy Commissioner Russo? Yeah, I mean,
Deputy Commissioner, can you identify yourself?
Yes, sorry. Matt Russo, Deputy Commissioner for DMV.
Thank you.
Yeah, so the fines currently those get deposited in the transportation fund and then they get reallocated in the coming years, but the fine really serves as a deterrent on the signs coming in. So right now the signs say $1,000 fine, or up to $2,000 fine. I'm not sure how AOT has worded it. They're now going to say $10,000 or $20,000 fine. So it's one more thing. It may not catch everybody, but the idea is to try to catch people's attention. If you pay attention, there are signs starting on I-89 in both directions, going all the way up to the notch. And there are flashing digital signs as you get to the chicane, which, by the way, you have to navigate through. And if you can't fit through that, you can't fit through the notch. My understanding is the last stoppage, the individual drove around the chicane and kept going past the flashing sign.
My understanding is there's also been like multiple former successful conversations between the agency and like Google and Apple Maps.
Yeah.
I'm sure that programming is being changed too.
Yeah, and the truck-specific GPSs route people around it now. The problem that really stems from folks who are using a GPS that's meant for a regular car and not paying the extra for the truck-specific GPS, which will route them around it. And also not paying attention to signage and other things going in. There's a lot that's being done to try to keep folks out. The hope is that the extra zero on the dollar amounts here will finish the job and keep this from happening.
Any other questions for Damien? Yeah.
I'm wondering how much testimony detail was taken on the section that has to do with when a car is found totaled and the insurance company gets the title.
So there was a lot of testimony in both the House and Senate on this. The request is not changing the underlying authority to seek that title. And to be clear, the car is totaled. Your insurance company has paid you the full value under your policy for the car. And they have to submit proof that they've paid out the policy on the car. And then they can apply for this. And what this is essentially covering is allowing them to get electronic signatures. And there is a separate process in the event that they're not able to get the title. There's a process for them to provide certification that they've made an effort to get the title, et cetera, from the individual. But you have to provide the title document, the odometer disclosure, and other documentation, powers of attorney, et cetera. And this is allowing them to do that with an electronic signature. And there is an indemnification provision here where they have to indemnify the department if they're using the electronic signature option to get this salvage certificate for the car.
Thank you. We're running out of time and we still have some work to test. Oh,
Amy, is there anything about the electric vehicles?
You're thinking about the mileage-based user fee?
Right.
That's in the transportation bill, which just passed the Senate.
I think we have that scheduled.
And I think you have that scheduled for later this week, and I'll walk you through what they did to that. Yeah.
We will indeed.
Yes.
Okay.
All right.
Representative Odie, do you want to finish your questions or are you good?
If they can't get the title, does that mean that the ownership remains with the person who has?
So the way that works is, so there has to be, when you get the salvage title is basically a title that says this car is totaled, you're getting a salvage title, and there may be, at that point, I gotta check the statute here, but maybe, do you have a clarification on whether there's a flag that comes if you didn't get the actual underlying certificate of title?
We just send out, we don't have to have the title, physical title. We just send out a letter to the lien holder and to the owner. we don't receive a response back, and it's automatically labeled abandoned, so I go to the. So if we don't have a response from the owner, then we will title it to the tow company.
Damian, can you show us the amendment?
Yes.
So this amendment is at the request of the Department of Taxes and the Department Agency of Transportation, Department of Motor Vehicles. I don't remember. Okay, great. Thank you. Agency.
Yeah, so
Um,
it was here, and I think you had to step out.
Sarah from Tax is gonna cover it for both of them.
Great.
And the Transportation Committee has not heard it yet, but Representative Walker said it made sense to him.
Yeah, so this basically allows the Department of Taxes in the commissioner's discretion, and subject to conditions and requirements and any confidentiality requirements of the IRS, to disclose tax return information related to tax revenue generated on the premises of airports in the state to AOT as necessary to demonstrate compliance with FAA grant funding requirements relating to airport revenue. So there is a requirement with taxes on aviation fuels that all of those tax revenues be put back into aviation infrastructure or other aviation related purposes. And so this would allow AOT to provide evidence of that for purposes of their FAA grants.
This is a very, very narrow disclosure. It's
Yes.
just for the purposes of reporting to the FAA.
For grant compliance.
Okay, great.
Yeah. So that's it here. And it just, yeah, very short. It was drafted by Kirby. So, whoops, meant to stop my share there, not close the window. Yeah, you don't have to worry that I meddled where I shouldn't.
Thank you. Thank you, Damian. Appreciate it.
Yeah. All right.
Again, can you share things with us now?
Yeah.
Thank you. And at 4 o'clock, Bradley's gonna come back for 323.
The record, Logan Moore at the Joint Fiscal Office, fiscal note for you. There really should be on your committee page. There are really 3 sections of this bill that I think are pertinent to this committee. First one is section 15. That's the non-domiciled CDLs that you heard about. That's the $40 yearly fee to get a non-domiciled CDL license. In 2025, there were 16 non-domiciled CDLs issued in the state. So given that small number of instances and people that have the applicant, this is de minimis impact.
So it was already a $40 fee. We're just saying it's a shorter time frame that you can get the fee.
I believe they had to get a 2-year or a 4-year one. There was just only 16 non-domiciled ones issued in total. So if everyone switched to a $40 fee, it would be de minimis. Section 24 is the limited use specialty vehicles. That's the registration for them. It's $26 annual registration. And then the language states that the commissioner can issue a maximum of 12 of these registrations per year. The math there is also de minimis. And then 27 is the non-de minimis section. And I think this one might have been accidentally skipped in Damian's presentation, but this is the repeal of the DMV's ability to electronically issue a temporary license plate or registration that then will be printed by the owner of the motor vehicle. So they would, my understanding is issued to you and you would get it at home, print it off, and you could use it for up to 60 days. This would no longer be allowed due to a number of issues that I think the DMV could better speak to.
Was that a pandemic era?
It was, I believe in 2019, we did that because of a significant backlog at the DMV. Now it's becoming a much larger issue. I understand it was $6 you'd pay. In 2025, they issued approximately 33,000 of these. So that generates roughly $200,000. As of November 2025, the DMV has stopped issuing these, and so they haven't been collecting any of this revenue since then. But sort of per statute and given numbers last year, this would sort of represent the loss of $200,000. Again, we currently aren't collecting it and haven't been for a while, is my understanding. So this is sort of the big of the section in here, the one that actually has a sort of larger impact.
This might be a question for Damien, not for you, but did they have authority to stop issuing them before we repealed this language?
So, this is a somewhat complicated question, but I think that if we look to the general authority of the commissioner to sort of ensure that fraud is not occurring, then the temporary pause is fine, but for a permanent change, the commissioner would not have that authority, which is why you need a permanent change to the statute. So my understanding is that the department became aware that there were likely a number of these that were being issued or used fraudulently. And temporarily paused it and then sought a change to the statute based on this. And so I think that that falls probably under the general authority of the commissioner to administer the statute, at least arguably. So there's no express authority.
Okay.
But if we read the statute, I think you can find it in a
Thank you.
reading of the general authority.
Any questions for Logan? Yes.
Actually, maybe it's not a question for you, just a comment. $200,000 giving the transportation fund is a hell of a lot of money. I'm surprised that that's agreed to. Maybe we need to talk to someone else to get that sorted out.
Yeah, we can ask the agency. Anything for Logan? Okay, thank you very much.
Of course.
Deputy Commissioner,
Yes.
are you all okay with this loss of $200,000 in revenue?
I think that we look at it as the amount of tax that we were losing. The birds that were being printed for $6. And we use their ID number to get another one for $6, and it just got passed on to the manufacturer for certain vehicles.
Oh,
Very, very large amount of things that we're doing.
wow.
Well, so
So you're really closing a big fraud loophole.
Exactly.
Okay, thank you.
any.
So we'll make money off of closing this.
Any estimate of the number of vehicles and of revenue loss?
Not specific to the amount of revenue. Say it's like 30%. Product to be registered, maybe 40%.
We get a temporary registration and then 30% goes to just.
So just keep on passing you up.
This is a comment. It would be nice if the fiscal note couldn't be updated. It would be nice to have just a pen and paper. Side by side, the tax loss first. So the loss. That makes sense. I mean,
It does, it would be hard to track down how much, what the value of the vehicle was or how much they sold it for.
understood.
So we can probably estimate that would be with the minimum value.
Sure.
I don't know if we could put that in the fiscal note, but maybe we can get an email from the agency with their estimate of the loss.
This fiscal note is done, at least, but it would be nice to have an email that explains that, because someone's gonna ask. There ought to be an answer.
Absolutely.
Thank you.
Thanks.
So, I mean, when you see 33,000 vehicles, like, wow, that's a successful program.
Understood.
That's good. That's good,
Understood.
but maybe not.
Okay.
Thank you. Any other questions anyone has? Thank you. Can I have a motion to find the amendment favorable?
326,
It is.
Madam Chair, I would move that we find the amendment favorable to S 326. I believe it's draft 1.2.
Thanks. Any discussion? Seeing none, if the clerk could please call the roll.
Representative Brannigan. Yes. I'll vote yes. This Representative Burkhardt, Representative Higley,
Yes.
Representative Folcom,
Yes.
Representative Kimball,
Yes.
Representative Maslin,
Yep.
Representative Odie,
Yes.
Representative Page,
Yes.
Representative Wazazak is not here. Representative Canfield
Yes.
and Representative Kornheiser.
Yes.
We have voted the amendment favorable 10-01.
Now that I'm sure, I move that we find the bill as amended favorable. That's 326.
Representative Kimball moves that we find S 326 as amended favorable. Any discussion? We don't need seconds, no. Very established, no needing of seconds here. Any discussion? Seeing none.
Right, Representative Brannigan.
Yes.
I'll vote yes with Representative Burkhardt, Representative Figley,
Yes.
Representative Holcomb,
Yes.
Representative Kimball,
Yes.
Representative Maslin.
Yep.
Representative Odie. Representative Page. Representative Wazazak is not here. Representative Canfield,
Yes.
Representative Kornheiser.
Yes.
We have voted the bill favorable as amended 10-01.
Thank you. There you go, this one. Okay. We're gonna take a 5-minute break while we wait for Bradley.